YouTube, it's Tone, back with another one for you. This one is a continuation of the court survival guide. This is the 7th video here, and let's get right into this shit. I think this is a lot of interesting things in this book. So, right, what do we got? So in reality, you are the one who actually represents the people, defending yourself against the fraudulent agents of the government who actually represent the banks and the corporations hidden behind them. So your purpose is to logically present these contradictions and motion to dismiss because the case is misrepresented, or mistrial, or motion to dismiss for cause of fraud. So you can see that they will not want you to win the game here, because this is the basis for their whole game plan, and they would not want to let the word get out. So just be sly as a fox and hang in there and watch them try to squirm around the real issues and offer lame excuses. See the strategy stated above. You may just prove that the DAs or the DDAs fraud simply by asking to see his or her license to practice law, his or her certificate or title of nobility, or his or her green card. And so, I mean, those are all, you know, so like those are all things that you can pull on them if you want to, you know what I mean? So, but they, you know, they will have that. They will have, you know, ask them for their license to practice law if they claim to have one and all that. The foreign agents identification and all that shit too. I mean, they, you know, there's a lot of things that they have to do to really sit there and have a face and act like they don't know what you're talking about, because they literally have to go out of their way to do all that shit. So they know they know exactly what the fuck you're talking about. So strategy 6, challenge the law. This motion to dismiss is where you dig into your state statutes and find all the holes that they were entrapping you with. Look up the definitions used and look up the definitions used and established in the beginning of the chapter. The statutes are deliberately written to deceive us into a fraudulent state of agreement and compliance. So you must get into the semantics. Semantics is words and their definitions. So find a logical relationship between the statutes and the definitions of terms. Hang on a second. So, what the hell was that? So the statutes are deliberately written to deceive us into a fraudulent state of agreement and compliance. So you must get into the semantics, the words and definitions. So find a logical relationship between the statutes and the definitions of terms to construct a deductive conclusion that the statutes that you are being charged with cannot possibly apply to you, and that there is insufficient evidence to support the charges, such as no injured party, no contract binding you to the statutes, no property damage, and no evidence of your status as a government slave. So you may get several motions out of this strategy. Make sure that each written motion completely describes in detail your logical reasoning and references where you are quoting the statutes from. Also, make a photocopy of each legal reference from the law library so that you can place it in the judge's face. The judge will try to ignore the legal evidence and present that you present in person on the basis of not having the statutes in front of him or being too pressed for time to hear your entire presentation. So be ready to shoot down the lame excuses and walk the judge through every argument, definition, and conclusion. And these motions to support the result, your resulting verbal motion to dismiss in person. So you got to get it in paperwork too as well. So also, to reinforce your logical arguments, you may decide to quote several cases, court decisions, and legal documents that say the same things that you are claiming to be true. This will oblige the judge to acknowledge the decisions of other judges and to rule in your favor. So you must have referenced case types separately at the top of each page. Include these with each motion that you are using them for, in this fashion that you may not be able to swamp the judge with so much evidence that he or she just gives up and dismisses the case. So here are a few more constitutional, traffic, and travel-related sources that you can use. The Supreme Court constitutional right may be claimed by a belligerent claimant in person, propria persona, that's proper person. So you have to be in your proper person in order to state any constitutional rights there. So then we have a case here Hurtado versus California. The state cannot diminish the rights of the people, and of course they can't, because the people who created the state, so the state can't have more power than the people. It's not that complicated. So many people automatically take the assumption that the state statutes laws are passed to restrict the rights of only the bad guys. Wrong. Everybody's rights are restricted and limited. Chicago motor coach versus Chicago. And so this is stating different cases here where they cite that information for you to corroborate if you were going to try to put it in some documentation for court or something like that. And it just goes through the little things here. So one of the other cases is Sherrod versus Cullen. So 481 946. So for a crime to exist, there must be an injured party. So there can be no sanction or penalty imposed on one because the exercise of a constitutional right. So a constitutional right cannot be converted into a crime, essentially, okay? So Kent versus Dulles, the right to travel is part of the liberty of which the citizen cannot be deprived without due process of law under the Fifth Amendment. And that's a fact as well, too. And the Supreme Court's even made it pretty damn clear for these people that keep on suspending everybody's licenses for civil matters. And they say, and they state clearly in the notice that you can even find, that you can find in my video archives of me showing the Supreme Court noticing all the states as to the illegal nature of them suspending people's licenses just for a matter of money, when the only reason that they are legally able to take it from you is if you become a what is it? If you become a threat to the public, essentially. So that's what it is, a public threat. So, and then here we have Miranda versus Arizona, where rights secured by the Constitution are involved. There can be no rulemaking or legislation which would abrogate them, and you already know that. And the only reason why they're able to write all of those codes and statutes, like we already went over, is because they are a private commercial entity, and they're essentially just making rules for themselves and the people that they do business with. That's it. So it isn't for you necessarily, unless you choose to be under their jurisdiction. So, under our system of government, upon the individuality and intelligence of the citizen, the state does not claim to control him or her, except as his conduct to others, leaving him or her the sole judge as to all the effects of him or herself. So if you become, pretty much if you end up in somebody else's movie and you possibly could become an issue to somebody else, then you're not so individual anymore. You're kind of blending into somebody else's reality, and then so there's consequences for everything, essentially. So Declaration of Independence, Part 2. Governments derive their just power from the consent of the governed. Obviously. Sheer, math alone just shows you that that's the case. Because it isn't by anything else other than the consent. Because numerically, it doesn't make sense that you think that you're just strong-arming the whole population. Because you just don't have, nobody's arm is that strong. So obviously, there's fucking consent there. Now, how willing is the consent? Now, that's another topic. So strategy 7, demand the evidence. When it's your turn to introduce the evidence and testimony, that is when you are bluffing the court into exposing their fraudulent jurisdiction over you, it is your driver's license and application, i.e. government contracts, which binds you to the traffic statutes. So given that you haven't rescinded your contract, then this is what's really holding you liable for complying with the statutes, of course. They don't want to reveal that to anyone. So here you must simply declare that the court has yet to prove its jurisdiction over you under the insidious 14th Amendment. And that's a good strategy too, because then by saying something like that, so look, so even if you know that they have jurisdiction over you because you have the driver's license, and that's a petty reason to try to act like you have it, you know what I'm saying? You have to act like, you have to play dumb and say that they don't have the jurisdiction in order to get them to prove that they do. And if that's the reason why they do have it, then they should put that shit on paper for somebody to put that shit in the newspaper. But they're never going to do that. They're never going to be like, oh, look, it's because you have a license and all that. That's not what they're going to say. They're going to just try to freaking avoid that and only focus on the ticket and violation instead of all, all those little details. So, and demand that the court place in evidence the contract that they must be using to enforce laws upon you without your consent or knowledge. Do this especially if you have reversed your right explicitly reserved. It says, excuse me, that's just kind of blurry. Reserved your rights explicitly at the beginning of the hearing, and so that's a good thing to do too. So when the judge refuses the motion to dismiss because of failure to make evidence to establish jurisdiction. So if they refuse to budge, object, and ask the judge if he or she has made a judicial determination that violates your reserved right to introduce evidence relating to your case. Strategy 8, motion for recusal. This is perhaps your last chance to avoid going to trial. You can use this strategy now, at the plea bargaining, or anytime up until the trial. So because your judge has steamrolled over all your previous attempts to educate the court in its errors, you are demanding that the judge to dismiss himself from the case, and here's the drill. The accused feels that this court is not only wholly prejudiced against the accused, but it is so totally uninformed and ignorant to its nature, authority, responsibility, and application of. Hang on, let me. What do we got here? And its application of remedy and law, and specifically with respect to jurisdictional fact, as to make any further hearing of this matter before the court extra jurisdictional, and therefore makes any subsequent verdict of guilty by this court or by jury subject to immediate reversible error in appeal. If the judge accepts this, then you get to start all over with a new judge with your new and improved techniques and strategies. So strategy 9, move for a finding of fact. This is for any time that you have successfully cornered the judge into making questionable judicial determination and some rule or issue affecting the case. You are sure that he or she is trying to hide something, such as evading your questions. This is fraudulent, and you are prepared to expose it, whether the finding is yes or no. One way, you are exposing the judge's lie, mistake, or fraud. The other way, you are reclaiming one of your rights that you will prove your defense either way. You can't lose. So you can only embarrass them toward dismissal, dig into the details of the real law and the real issues. And the details is where the damn devil is. The devil is in the details. So strategy 10, motion to subpoena witnesses. This is your reserve plan to buy more time before trial, if any, and to summon hostile witness for your questioning during trial. You have the right to call any witnesses to stand during trial, but if there is someone who does not want to be there for you, you need to formally identify who they are and their addresses and explain that their testimony is vital to your defense. The courts must then issue the warrants as a result of the motion hearing and serve them from the sheriff's department. They cost about $15 each. The judge may try to deceive you into believing that you somehow are not allowed to do this, like intimidation, so get it all out on the record, corner the judge, and or explain that you will not let him or her cheat you out of your Sixth Amendment rights. So strategy 11, put the judge on notice to appeal. So you must use this courtroom strategy every time the judge rules against your presumably valid motion, any of them. The judge will try to intimidate you by ignoring the legal issues that you present with your motions. So pretty much acting like he didn't get them. So here is where you verbally put the judge on notice that you intend to appeal his or her ruling because you know that he or she is violating your rights of the law and or is committing fraud. The main purpose is to object to the ruling, the state on the record why you believe the judge has made an error, thereby recording useful evidence against him or her. So strategy 12, agree to nothing. This is an absolute must. To use with all of the above strategies, just in case the prosecutor attempts to pull a fast one. If the prosecutor should ever propose a motion in limine or anything in limine, you must flat out object and refuse. This is an attempt to prevent you from introducing your evidence and to properly defending yourself on equal footing. Do not agree to any such motion by the prosecutor. In fact, do not agree to anything that the prosecutor deliberately says fast so that you do not understand. Better yet, the motions hearings is your show. Do not agree with anything or any motion that the prosecutor has to offer. Object. Strategy 13. Additional strategies. There are some procedural options that you can motion for, such as motion to trial by jury, motion for a jury of 12 instead of 6, motion to participate in the jury selection, motion for the court to pay for the cost because you are broke. Just remember that. So all right. So So you are now swimming upstream and dealing with the particulars of your case. Now, fully under the fraudulent statutory jurisdiction, by now you are probably at risk of losing the chance to challenge jurisdiction in the eyes of the judge. So you should make this your highest priority. And make sure to read up on your general rights in the courtroom as described in the beginning of this guide, and you should do just fine. All things considered, and again, be sure to bring all your friends and your personal legal counselors with you to your motions hearing. They're going to know who you are. They're going to know who you are. And it's funny too, man, because I think people do want to see that. Because nobody really gets to see that because it's always in an empty courtroom that's going to happen. It's never in front of the general population. So purpose. The official purpose of the trial is to test and determine if a crime has indeed been committed and whether or not you are guilty of that crime. Of course, you already know that they have already decided that you are guilty. Have already harassed you, threatened you, intimidated you, insulted you, and treated you as guilty. Your vehicle may have been impounded, and you may have already been arrested as a criminal. So mostly, this big to do about the trial is to make a grand showing to the people to prove just how dangerous and evil you are for standing up to your rights, thereby threatening the system and the racket. So your purpose, since you have sunk into it this far, is to get the case dismissed before the jury or judge makes a formal decision on your guilt. What to expect. The longer your case is in the court, the more it will feel like the legal system is some large corporate bureaucratic nutcracker and more firmly clasped to one of the delicate parts of your anatomy. The prosecutor will attempt to deceive everyone into believing that his or her illusions. The judge will pretend to be a fair referee during the entire trial, which will consist of conference, jury selection, jury instructions, opening statement, testimony, final statement, and deliberation as follows. Pre-trial conference. In the judge's office, they will tell you that there are important matters to agree on before the jury selection, such as your list of possible witnesses, that you are there only because they need and want something from you. Here is where they will politely try to con you out of your rights, the jury's rights, and then politely threaten you off the record. They are just testing you to see if you know how to defeat them and sizing you up to see just how much they can get away with. So here is where you will see just how vital it is for them to control you. So the jury, the procedure, and the final decision. The judge will probably attempt to hold you responsible for conducting your case in a licensed attorney. You may just decide to put the prosecutor on the stand to explain the nature and cause of the accusation. Imagine calling the prosecutor on the stand to have him explain to the court what the cause and nature of the accusations are. Come on, man. I do want to see some shit like that, to be honest with you. I mean, that'd be fucking amazing. So, jury selection. If you have chosen to have a jury, you will agree on the procedure and then interview prospective jurors one by one to determine whether you want them to decide your case. You will ask them specific questions relating to how they feel about the issue relating to your case. This is called voir dire, which means you want some idea of how they intend to perceive your case. And so that essentially is going to be like the filter that they're going to be seeing things through, right? Which comes down to your programming and shit like that, which everybody's got a program. So you will be able to dismiss some of those that you feel will decide against you. Then you will be politely asked to pass the jury for cause, which means you accept the jury as it stands to rule on your case, and they will not tell you that you can refuse the jury for cause. So jury instructions. If you have a jury, you, the judge, and the prosecutor all have the right to propose formal instructions for the jury to have copies of. They will be dictating to the jury exactly what they want them to know about and only what they want them to know about. So you should also prepare some jury instructions ahead of time. You see the strategies below. And then the opening statement, apparently, right? So this is where the judge and the jury, if any, hear from both sides why they are here, why you are here, what they intend to show, and what they can expect to bear as evidence and testimony. So you need to have this typed up ahead of time, summarizing the essential understanding of why your defense is superior to the prosecutor's offense. Testimony. This is where both sides take turns calling witnesses to testify on their behalf to establish their respective positions. You will be asking your own witness specific questions that you have prepared ahead of time. After the prosecutor asks his witness questions, then you can shoot down their evidence by asking them your own questions during your cross-examination. The final statement. Here is where you summarize what has happened in the court, where you have logically shown what the witnesses have clearly established, what conclusions have obviously been revealed, and why the judge or jury must therefore reach a verdict of not guilty. If you have a jury, this is where you must emphasize and re-emphasize your few basic points. Here, you must also remind the jury of their instructions and their duty to bring the justice into the court, which is representative of the people. Deliberation. Nothing to do here but wait. You're done. The judge is the jury. The judge or jury is deciding a case. Whatever you left unaddressed in the court is now just hypothetical history. What to do? Know your stuff, know your rights, work out your plan ahead of time, be prepared to take every opportunity to win. Expose, embarrass, and keep the prosecutor and the judge from getting away with this fraud and abuse. Try to win the case before trial. If not possible, try to win the case before deliberation. The closer you get to that, the less likely your chances of winning. Here are a few more ideas. The strategy. 0. Motion to dismiss by default before trial. Use this if the current date before your trial is already more than 6 months after the citation date. Send in this motion with a notice of default stating that the court has already violated your Sixth Amendment right to a speedy trial, thereby avoiding the case, and you win. Strategy 2. Strategy 1. Recuse the trial. Recuse the judge before trial. They really don't want you to know about this one. This is a delay tactic in which you are dismissing the judge several days before the scheduled trial because you have discovered something about him or her that compromises the trial from being fair, such as being biased against you, violation of his or her oath of office, failure to record such an oath with the proper office, misconduct on a previous hearing, or known of a record or a known record of hostility toward the accused, failure to show evidence of status, green card, title of nobility, attorney's license, or certificate of status. Guess at this if you have to. These judges are all crooked. You're bound to hit a tender spot. This strategy gives you more time to prepare for trial and a chance to try any of the previous strategies again. So strategy 2 is called the bluff in conference. So here is where you are turning their own addiction to power and control against them. You bring your hidden pocket tape recorder with you into the conference the morning of your trial and have it on record mode with a fresh tape battery. As soon as you walk into the judge's office, you're going to let the implicit conversation and their hidden real intentions unfold and develop. So when they try to threaten you with the contempt of court or warn you not to tell the jury certain things and to deceive you into giving away your rights, such as trying to hold you to conduct your case as a licensed attorney, here is where you take the here is where you make your stand, and you are off the court record, so you can say anything you want and however you want. After all, that's what they're doing. So the shit is crazy too, man. And trial is really just a fucking dog and pony show. I mean, it really is that. It really is that. So, or horse and pony, whatever the fuck it is. So the thing is that, yeah, and I mean, I even went to trial for like some dumb shit a long time ago, but I had a lawyer and all that shit too, and like we won. But you know how strange it is to actually be innocent and then to fucking have to act. You're like, how do I look innocent? Let me just try to put off an innocent vibe. Like, that's literally what this type of dumb shit puts you into a position of, like, because like, how do you even prove that? Like, how do you look innocent? You know what I mean? So that was strange, but still, nonetheless, I mean, if you focus and, you know, just prove your points and hit your points home, you know, the biggest thing that you need to focus on is when you're there is asking the right questions to make these people tell on themselves. You know what I'm saying? And that's the thing. Like, that's the biggest thing. The right series of questions will literally back anybody into a corner where they literally have nothing to say, and or anything that they do say will just fucking incriminate them. And you can even ask questions to prove points. Rhetorical questions that you know are not going to get answered to get that shit on the record and or to sway the jury in any way and shit like that too. A lot of things that you can do. It's crazy. So anyway, it is a game of chess. Stop playing checkers with these people. That's what I got for you for now. Until we meet again.